Good afternoon. Loud. It's a pleasure for me to be here with you. This is my first time to campus. Long admired Emory. It's nice to set foot and be here in the flesh. I want to thank Professor Owlett for the invitation. He's the one who first reached out. I want to recognize Professor Owen. I don't know if many of you will have the chance to take his classes. I've known him not well in a personal way, but through his works, and I've spent the last week reading his new book, which is outstanding. So I highly, if he's anything, if he's as good in the classroom as he is in the written word, I would highly recommend you find your way to his classes. Thank you too to all those associated with the voluntary core curriculum program. I don't know much about it, but what I do know sounds fantastic. So I applaud all of you who had a hand in starting it and administering it and all the faculty involved with it. It sounds like a phenomenal opportunity, one that I hope many students will take advantage of. How many we're right at the beginning of the school year, I know, and how many first-year students are there? If you're a first-year student? Oh, very good. Okay, that pleases me. Despite being a voluntary core program, I'm going to presume many of you aren't here voluntarily. But you know, thank you for coming. So I wrote this lecture for you. It's a version, it's based on my book, and I've given a version of it many times, but I intentionally wanted to try to reach out to the first-year students. I presume you've only been in school for a week or two, and I want to thank you for coming, whether you're here on your own accord or not. And I want to encourage you to come to events like this one for the following reason. I mean, you've just begun an amazing journey. I would have never got into Emory when I was a high school student applying to college, not even close. And to be at a world-class university like this that brings in scholars, cultural opportunities, plays, theater, what have you. I mean, I'm sure this place is just an amazing place to spend 3 or 4 or 5 years. And I think if you're like anything like my students don't take advantage of 1/10 of the opportunities before them. And they all come back after they graduate and they say, I wish I'd done more. I'd wish I'd gone to a lecture that I hadn't, you know, that was beyond my immediate curriculum. I wish I'd done stuff to push my intellectual boundaries. I wish I'd taken the time to read books or go to talks that you know, I just didn't go to. So hopefully, if you can give me your attention for a half hour, 45 minutes or so, this lecture will be good enough that convinces you to go to others. And your time here, your 4 years here will be amazing in the classroom, outside the classroom. But there's a whole intellectual life you can live at a university that's outside the classroom. And it pains me that students don't take advantage of it. And so it's such a wonderful opportunity, and it's a thrill for me to be part of it. That's why I always accept invitations like this. So I encourage you, given the type of program you have here, to take every advantage of every opportunity you can. Okay, so let me see if I can make this lecture worth your while. For over 60 years, lawyers, judges, scholars have debated how the founders attempted to separate church and state and how they intended to protect religious freedom. From time to time, we're in the midst of one of those times right now, and this happens usually when a federal court, often the Supreme Court, makes a controversial decision. This academic and scholarly and historical debate moves into the public consciousness. In 2002, this is ancient history for many of you, the Ninth Circuit Court of Appeals declared under God and the Pledge of Allegiance unconstitutional in public school recitations of the Pledge of Allegiance. When they did so, conservatives decried liberal judicial activism, as they're doing right now, and how liberal courts were betraying the founders' political principles. And it is true, usually, that the founders tend to work for Fox News in these matters. But liberals, too, appeal to the founding fathers. So when a narrow court majority, made up of conservatives, upheld the 10 Commandments monument on the grounds of the Texas state capitol in 2005, it was the court liberals who decried the court conservatives for abandoning the founding fathers' idea of a secular republic. I hardly need to mention all the religious controversies that are on the airwaves right now. Hobby Lobby, the HHS mandate, Kim Davis, and how the founders repeatedly find their ways into these debates. So considering that the modern Supreme Court, first cited Jefferson and Madison to guide our First Amendment jurisprudence in 1947, considering we've been at this for almost 75 years, you would think we would have figured out how the founders meant to separate church from state and how they meant to protect religious liberty. But through 3 generations of scholarship, 3 generations of judicial decisions, 3 generations of debate have left judges, scholars, and the American public more divided now than ever before about our founding history. What I want to try to do with you is explain why this historical debate persists. And I'm also going to try to explain who gets what right, at least in my view. And to do this, I'm going to do 3 things with you. I'm going to start with the liberal and conservative stories about the founders on church and state. And then I want to go into at least my understanding of what the founders actually thought. And I'm going to focus on the 3 founders I know best, but also our 3 leading founders in these matters, Jefferson, Madison, and Washington. And then I'll conclude with a few of my own thoughts on how we might better appropriate the founders' competing wisdoms. Okay, let me begin with the liberal story. The liberal story goes something like this. In the beginning, there was persecution, and it was bad. Wars of religion devastated Europe. Catholics persecuted Protestants. Protestants persecuted Catholics. Protestants persecuted other Protestants. Everybody persecuted the Jews. Settlers came to America to escape religious persecution, but before long, the nastiness and the nasty old habits of the old world affected the new, because religion was intimately tied with politics, and religion by its nature breeds unreasonable and hence unreconcilable political dissent. The cycle of theological dispute leading to political oppression persisted until the founders, again this is the liberal story, the cycle of theological dispute leading to political oppression persisted until the founders built the first secular republic. The founders separated religion and politics, which secured freedom by preventing sectarian religious disagreements from contaminating political life. The key to the founders' solution in the liberal story is the privatization of religion and the elimination of religion from the public square. We see a new attempt to do this, I think, today. This privatization effort was furthered by the Supreme Court in the 20th century. Prayer and Bible reading were eliminated from public schools. Parochial schools, mainly Catholic schools, were prohibited from receiving some federal money. Many, not all, but many religious symbols were removed from the public square. All this was done, according to the liberal story, in the spirit of the American founding. The judicial authors of the story were Justice Hugo Black, Justice Brennan and Marshall, more recently Justice Souter, Justice Stevens, and Justice O'Connor, and on today's court, Justice Ginsburg and Kagan, and it looks like probably Justice Sotomayor. Okay, the conservative story. The conservative account of the founders has been written largely in response to the liberal story. For the most part, conservatives agree that the founders meant to separate church and state, but they deny that this means that religion must be separated from politics. Separation in church and state for conservatives means that the state may not favor any one particular church, but the state or the government can favor religion generally. Some conservatives tend to be suspicious of the founders' political theory. Maybe they fear the liberals are right. But all conservatives love the founders' political practice. Conservatives love to point out that the Declaration of Independence has 4 references to the divine. The first Congress, the same Congress that passed the First Amendment, enacted legislation appointing publicly funded legislative chaplains, and they did this the very same week they passed the First Amendment. 3 of our first presidents offered official days of prayer and thanksgiving, all starting with George Washington. And the Supreme Court under John Marshall opened its session with prayer. Actions, conservatives say, speak louder than words, and the founders' political activities reveal a long history of non-sectarian governmental support of religion. The authors of the conservative story include Chief Justice Rehnquist, now deceased. Today, it's Justice Scalia and Thomas primarily. It looks like Alito is also following that path. And the leading academic scholar on this is a former federal judge, now Stanford law professor, Michael McConnell. Okay, so who's right among the liberals and conservatives? Or maybe a more accurate way to put it would be which story gets more accurate. When I started the research for my book, I put my cards on the table, I fully expected the conservative side would be more historically accurate. But it turns out the historical record is far more complicated and actually far more interesting than either the liberal story or the conservative story would lead us to believe. My argument, as you'll see, is that the leading founders disagreed about the proper separation of church and state. What I'm going to try to show you over the next half hour or so is how Jefferson, Madison, and Washington offered distinct and different approaches to the proper relationship between religion and politics. Both the liberal story and the conservative story contain some truth, but both are also incomplete. And they mislead us and lead to incomplete understanding of God and the founders. Let me say something from the outset before I dive into these three thinkers. I'm going to just make all sorts of assertions, and I'm going to make conclusions of arguments that I'm not giving you the full argument. I say this so you know that I know I'm doing this, and also to invite you to ask questions, to press me where you think the argument is weak, to ask for further clarifications. I was told right before I came up here that you're a contentious and quarrelsome group. I hope that's true. I would love to, I will make sure to save sufficient time for any and all questions you have. So don't hold back. Feel free to challenge me or to ask for more elaboration. Okay, let me start with Thomas Jefferson. Jefferson is the most interesting founder on these matters to my mind. He's also the most difficult founder to understand, and he's interesting and difficult for the exact same reason. Jefferson did not practice what he preached. Just in other areas of his life, Jefferson said one thing but did something else. So when we reflect on our third president, we have to ask, is this Jefferson the rhetorician, or is this Jefferson the hard-headed, anti-clerical political actor? What Jefferson said is encapsulated in his Virginia, what he said publicly is encapsulated in his famous statute for religious freedom. This is my summary of the enacting part of the legislation. It was a bill that was passed in 1786 in Virginia. The bill recognizes 5 overlapping rights, and again, I'm the one who divided them in 5. It's just one paragraph in Jefferson's and Jefferson's statute. So Jefferson declares that no individual civil capacity should be affected by religion. But he will, as I'm about to try to show you, Jefferson repeatedly tried to impose special civil disabilities on members of the clergy. And focusing on this one contradiction is the way I want to show you why Jefferson is difficult and why I think in some ways contradictory. For example, in 1783, Jefferson drafted a proposed constitution for the state of Virginia. Drafted it right about the same time that he was working on the Virginia statute. In it, Jefferson excluded ministers of the gospel, that is religious preachers, from eligibility for election to the General Assembly. Now, why did he do this? When asked about this exclusion, Jefferson responded in a surprisingly candid manner. He wrote, "The clergy are excluded because, if admitted into the legislature at all, the probability is that they would form its majority." Jefferson said clergy had to be excluded from the ballot because if they weren't, they would win. And clergy couldn't be allowed to hold political office because clerical power, he wrote, has filled the history of 10 or 12 centuries with too many atrocities not to merit a proscription for meddling in government, with government. Jefferson failed to get this exclusion in the Virginia state constitution, but his efforts to restrict clergymen's civil rights and reduce their societal influence would persist. In an 1817 bill, so a bill much later in Jefferson's life, An 1870 bill establishing elementary education in the state of Virginia. Jefferson was the father of public education. He had a whole scheme of public education for Virginia. When setting up public education in Virginia, he sought a legal prohibition against clergymen serving in the Board of Visitors, sort of like on the school board. He did not want clergy directing or influencing Virginia's public schools. This legal exclusion of preachers, of clergymen from political office was just one aspect of his larger church-state reformation project. Jefferson sought the transformation of America's religious opinions through public education. He insisted that young school children not read the Bible in Virginia's public schools. Young minds, he said, are, and I'm quoting here, not sufficiently mature for religious inquiries. He said instead that they should be taught morality with, again I'm quoting, the most useful facts from Grecian, Roman, European, and American history. He wanted Scripture banned from the curriculum so children's minds and imaginations would be kept free of the idea of miraculous truths and the idea of revealed dogmas, superstitions that he believed would inhibit the critical analysis of religion that he wanted more advanced students to undertake. And he wanted these students, these advanced students, to undertake this at his beloved University of Virginia. Of course, Jefferson is the founder of UVA, as I presume you know. He designed the curriculum at UVA he was effectively the first president or provost of UVA, or both. He designed the curriculum to minimize clerical influence. Instead of a professor of divinity, which was standard for, there weren't that many universities, but every university had a professor of divinity at the time, Jefferson proposed a professor of ethics. This would allow the university to teach morality without hiring a member of the clergy. And when he made his first round of faculty appointments, you know, you've all been to the mall on UVA's campus, you know, the famous lawn where there's 10 pavilions. Jefferson was the architect as well. And the professors, they'd live upstairs and teach their classes downstairs. You know, maybe not the best idea now, but this is Jefferson's idea of a liberal arts college. So he hired 10 faculty members, each one known for their heterodox religious opinions. So why did Jefferson want to keep Bibles away from school children and clergymen away from college students? Why was he willing to suspend the civil rights of clergymen, even in contradiction of his own stated principles of religious freedom? I mean, these are not easy questions to answer. Perhaps he was just contradictory. But I think what explains Jefferson's actions is that he held a progressive or a developmental view of religious freedom. Jefferson did not believe that we could simply ascertain fundamental rights and straightforwardly apply them. He thought religious freedom itself had to be established, and that required taking into account the social context, or what we might say the distribution of social power at the time. Jefferson was particularly keen to subjugate clerical influence in education because he thought that that influence stood as a barrier to progress in human thinking. He embraced the basic Enlightenment critique of religion and religious authority. He thought church institutions and church authorities invented theological dogmas to disarm human reason, and then they used those dogmas and the power of the government to suppress the ideas and individuals that might thereby then threaten clerical power. So if men were free, if American citizens were free from the artificial constraints that clergy had imposed, Jefferson believed they would be guided by reason and science alone. He was a true progressive insofar as he believed that to secure progress, one only had to remove what he called monkish ignorance. So to establish religious freedom required the subjugation of ecclesiastical religions and their influence on American society. The one sentence that encapsulates Jefferson's approach to church and state is not his famous wall of separation metaphor. This is, we all often think that the idea of a wall of separation is written in the First Amendment. That actually comes from a letter that Jefferson wrote but was quoted by the Supreme Court. That's not actually, if you want a slogan for Jefferson, it's not that. This is what he wrote in a private letter in 1813. History, I believe, furnishes no example of a priest-ridden people maintaining a free civil government. Although Jefferson articulated natural right principles in his famous Virginia statute, his approach to religious liberty is more accurately characterized as a politics that seeks to aid the march of progress by transforming and overcoming traditional religion and emancipating individuals and their minds and spirits. Emancipating individuals to develop their own minds according to the dictates of reason alone. So for Jefferson, religious freedom meant primarily freedom from the dogmas, influence, and priests of Orthodox Christianity. So it's no coincidence that the liberal story of religious freedom today holds Jefferson as its high priest. When the Supreme Court removed prayer and Bible reading from the public schools, this was back in the 60s, when it eliminates religious symbols from the public square, when it prohibits religious organizations from receiving public funds, in many ways it resumes the liberal project that Jefferson himself began. Okay, let me turn a little bit more briefly to James Madison. As you'll see, I quite like Madison. I like him in part because he is relatively, especially compared to Jefferson, relatively simple and straightforward. This is not to say that he's understood. Maybe despite being simple and straightforward, perhaps because he's simple and straightforward, lawyers always get him wrong. Madison is usually portrayed as the constitutional foreman that built Jefferson's wall of separation. They were political allies. They worked hand in hand, so it's not altogether strange that people would think this. This idea of Madison being the same as Jefferson, being the constitutional foreman as Jefferson, was initiated in 1947 by Justice Wiley Rutledge, for those of you who know constitutional law, in the Everson case. Rutledge and then Justice Souter more recently said over and over that James Madison was unrelentingly absolute in opposing any form of state support of religion. This view is not exactly wrong, but it's woefully incomplete. The scholars and judges who have appealed to Madison, they fail to understand the social compact theory that informs his thought, and in doing so have failed to understand Madison's principle of religious freedom. Let me go on a slight tangent here, if you don't mind, since there's so many first-year students here. So what I'm about to explain to you, it's going to seem a little bit academic, but let me try to draw the consequences. James Madison's opinions have been written into the First Amendment. And let me rephrase that. Certain interpretations of James Madison's opinions have been written into the First Amendment. Those interpretations, my argument is, are wrong. I'm here today because I made this argument that all these lawyers who litigate before the Supreme Court, all these Supreme Court justices have misunderstood James Madison's thought. Some people think I've said something interesting. That's what leads me to speak to you today. The reason why these Supreme Court justices and the lawyers they rely on him misunderstand James Madison is because they did not pay sufficient attention in their introductory history classes and introductory political science classes. What I'm about to say is very simple from the perspective, if you're in a first-year political theory class, you will understand what I'm going to get. But because most law students, most law professors don't understand social compact theory, they misunderstand Madison. Usually we think, okay, well, so you don't understand a lecture in political theory. But the consequences here are a rewriting of the First Amendment. One of the reasons, look, if you're going to do something important in life and rely on what you do in class, make sure you get what you do in class right. And now's the time you do that. Don't let your intellectual errors mess up the First Amendment. Okay, sorry. So Madison's most authoritative statement on religious freedom is a 1785 document. It's called the Memorial and Remonstrance. It's got a complicated history, but Madison writes his Memorial and Remonstrance to defeat a bill by Patrick Henry. I'll talk about this in a minute. So it's sort of Patrick Henry was on one side, and James Madison and Thomas Jefferson on the other. Patrick Henry, give me liberty or give me death. Okay, so Madison writes his bill in opposition to Henry's bill and in support of Jefferson's bill. In Article 1 of the Memorial and Remonstrance, Madison offers his most philosophical argument defending what he calls man's natural right to religious freedom. And I put up a lot of text here because I wanted you to see it. I mean, the argument, if you really analyze it, is relatively complex, but let me simplify it for you. Madison derives the right of religious freedom from the nature of religion itself. Religion, he says, involves opinions about God and our religious obligations. Opinions about our religious obligations. Our religious obligations, he says, can only be fulfilled according to conviction and conscience. To use modern terminology, Madison means that our religious practices have to be sincere to be authentic. Right? If you don't really believe it, it's not sincere religion. You can't fake religion. Right? God will know you're faking it, and therefore it's not true religion. This means, according to Madison, that we cannot give the state, the government, authority over our religious opinions. Because opinions follow evidence alone. Opinions cannot be coerced in the same way that actions can. Because opinions cannot be coerced, the force of law, which can reach actions but not beliefs, cannot lead men to saving belief. Right? Law can't make you believe something. It can make you act in a certain way, but can't make you believe something. But because religion is essentially a matter of belief, law can't lead you to saving belief. That's his argument in a nutshell. Okay, what does he draw from that? He says, it would never be in our interest, accordingly, to give authority over our religious opinions to the government. Just as a rational man would never sacrifice his eternal soul for the temporary goods of his body, individuals who have been made to worship God according to conscience should never give their religious duties, authority over their religious duties, over to the government. So the nature of religious obligation, Madison says, makes religious liberty a special kind of right. He says it's an unalienable natural right. And for Madison, this has a very powerful implication. He says, we maintain, therefore, that in matters of religion, no man's right is abridged by the institution of civil society, and religion is wholly exempt from its cognizance. What does the word cognizance mean? Used in a legal way, cognizance means the action of taking judicial or authoritative notice of. It means, in general, jurisdiction, or it can mean knowledge or perception or the state of being aware of. So a state non-cognizant of religion lacks jurisdiction over religion. Okay, what does all that mean? If I say the phrase a colorblind constitution, you know what I mean? I mean, you may or may not agree with it, but you know what I mean, basically, right? Colorblind constitution. What Madison is saying here is the nature of religious obligation means we must have a religion-blind constitution. In a religion-blind republic, lawmakers cannot take authoritative notice of or perceive in a legal way the religion or religious affiliation of citizens. Lawmakers cannot make distinctions between religious and non-religious citizens. The law cannot use religion as a ground of privilege or a ground of penalty. Madison's teaching on the proper relationship between church and state is state non-cognizance of religion, or a religion-blind constitution. And with only a handful of exceptions, Madison stayed true to this principle for most of his life. Let me give you an example. So I said the Memorial and Remonstrance was written against Patrick Henry's bill. Well, Patrick Henry's bill, and back up a little bit, give you a little historical context. Who's the Declaration of Independence written against? Who's the bad guy in the Declaration of Independence? What's that? Yeah, England, and who specifically? The King George, right? Who's the head of the Anglican Church? King George, right? So the same person that we're holding a revolution against is the head of the Anglican Church. The Anglican Church is established in the state of Virginia. What does that mean? It means that ministers are licensed by, or the colony of Virginia, I should say. Ministers are licensed by the state. The government owns all church property. It owns the church building. It pays the salaries of the ministers. Think of sort of public schools today, right? And the head of the Anglican Church, which is legally established in the colony of Virginia, is the king we're having a revolution against. So the revolution necessarily means we're going to have a revolution in our church-state arrangements in Virginia, right? We're not going to keep the king, we're not going to throw him off politically, but still have the established Anglican Church in Virginia, right? So things have to change. Well, how should they change? Well, after the Revolution, Patrick Henry proposes a bill. Patrick Henry is a huge player in Virginia politics. He'll become governor. Patrick Henry says, well, we should have a bill supporting Christian ministers. And so he says, we'll have a property tax, 5%, I don't know if it's on your income or whatever, but you pay it in tobacco, right? And those monies will be used to fund the clergy, take care of the clergy's living expenses. Clergy were, before paid by the state. The argument is, look, we're a free people now. A free people needs to be educated. The clergy will provide the education. All the reasons we support public education today, Patrick Henry says that's why we should support ministers with this tobacco tax. Madison rails against that proposal in his memorial and remonstrance. And his argument is government has no jurisdiction to impose a special tax for the purpose of supporting religious ministers. It's not that he was simply against the tax as bad policy. He says that's not a legitimate function of government because religion is no part of the jurisdiction given to the state. For the exact same reason, he opposes Jefferson's limitations on religious clergymen's civil rights. All right? So I mentioned Jefferson tried to restrict the clergy from the ballot in his proposed constitution for Virginia. Madison wrote to Jefferson and he criticized this, saying, your proposal violates a fundamental principle of liberty. Right? Now you have to think, Jefferson is Jefferson, and Madison is, he's still Madison, but Jefferson is his, neighbor with a nicer house and the statesman. And he says to Thomas Jefferson, you are violating a fundamental principle of liberty. Right? That was audacious. Because the state has no business taking cognizance of religious opinions, and that means the state can't privilege religion or it can't penalize religion. So it is true that Madison stood against state action, such as government funding of religion, that directly favors religion. But Madison also stood against state action that penalizes or excludes individuals on account of their religious affiliation. So a Madisonian approach to the First Amendment would not support the liberal jurisprudence that, say, eliminates religious schools alone from receiving government funds or excludes religious groups from accessing public spaces. These dogmas of strict separationism discriminate against religion from a Madisonian point of view. Madison also would not allow special privileges for religious citizens alone. Madison's principle is no privileges on account of religion, no penalties on account of religion. So Madison doesn't correspond really to either the liberal story or the conservative story. I'm not exactly sure how we ought to label Madison. Maybe we could say he's a libertarian in these matters. Okay, even more quickly now, let me talk about George Washington. When you study George Washington, you can't help but notice how different his politics are from Jefferson and Madison. Washington consistently tried to use governmental authority to encourage religion and to foster the religious character of the American people. I mentioned that Madison railed against Patrick Henry's bill. Well, George Washington originally was in favor of it. Yeah, he didn't like it because it caused a lot of controversy, but he said he wasn't against it. He actually says, I'm not against taxing citizens to support at least their own religion. Washington supported military chaplains. A second example of how his politics were different from Madison. Madison said chaplains were unconstitutional. Washington said chaplains helped to improve discipline. Military chaplains helped improve discipline, raised morale, they checked vice, they fortified the courage and bravery of soldiers. Washington said they helped secure obedience to command and therefore were absolutely essential to the war effort. As president, Washington inaugurated the tradition of declaring official presidential days of fasts and Thanksgiving. This is another point of difference from Madison. Now, it's a little bit complicated because Madison actually issued 4 presidential proclamations declaring days of fast and Thanksgiving of his own. But after he left the presidency, he said these acts were unconstitutional. Congress made him do it. Sort of sounds familiar, right? Washington took no such view. Oh, here's what Washington says about Patrick Henry's bill, that he supports funding of religion. Washington's first proclamation begins that it's a duty of the American people to recognize the authority of Almighty God. So the uses of taxes to support religion, military and legislative chaplains, presidential religious proclamations, all these exemplify the distance between Washington and Madison on the proper disposition of government towards religion. Washington did not think the state should be blind towards religion. He agreed with Madison and Jefferson, at least Jefferson, what he publicly said, that religion is a natural right and the purpose of government is to secure rights. But Washington did not translate those political principles into specific limitations on governmental power. Washington's most definitive statement on the subject, in fact, is in favor of state support of religion. I have this slide here for one specific reason. Washington's famous farewell address was not a speech he gave, but rather an address he published in the newspaper, as if published in the New York Times. Right? So this was how the farewell address. He didn't actually give the address. Again, a lot of text here, but I wanted you to have it. This is what Washington says about religion. Of all the disposition and habits which lead to political prosperity, religion and morality are indispensable supports. Religion is indispensable, President Washington explains, because tis substantially true that virtue or morality is a necessary spring of popular government. Virtue and morality are needed for public felicity because they prompt citizens to act in a decent and truthful and a law-abiding manner. Virtuous citizens govern themselves and they respect the rights of others, thereby reducing the need for security through the coercive force of law. Virtue and morality are indispensable because they make limited government possible. And religion, Washington says, is indispensable for the cultivation of virtue and morality. Let us, with caution, indulge the supposition, Washington warns, that morality can be maintained without religion. Washington does concede that a few might be made good on account of their refined education, no doubt thinking about students like you. But he suggests that most men require religion to fortify their character. Washington therefore endorsed the use of religion to nurture patriotic and moral citizens, something Madison thought was unnecessary and illegitimate. But from Washington's perspective, Madison's religion-blind approach ignored the reality that democratic Republican government needs religion. To separate religious morality from government support imprudently would destabilize the foundation of the moral character on which our whole edifice of government stands. So when conservatives say that the founders endorsed religion in general, perhaps even Christianity in particular, I think they have in mind founders like George Washington, like Justice Scalia and Justice Thomas, and many cultural conservatives today. Washington thought the government ought to favor religion because religion helps cultivate the citizen virtues necessary to sustain a liberal democracy. Okay. I know I'm going on a little bit long here. My argument, as you no doubt can tell by now, is that these three leading founding fathers disagreed about the proper separation of church and state. In today's terms, Jefferson would be a progressive liberal. Again, I think maybe we can label Madison a libertarian, Washington a cultural conservative. Okay, so where does this leave us? If I was a historian, I could just stop right now. But I want to be useful, so let me, that was for Professor Owlett, just for him. I'm so disappointed he's not here. So let me try to draw some lessons that we can take from this disagreement. From the perspective of jurisprudential originalism, I'm going to talk shop here for just a minute. From the perspective of originalism, strictly speaking, it's the Constitution's text, the public meaning of the text that is binding, and not any sentiment of any one founder. But because the religion clauses, the text is unclear what they mean, justices and scholars tend to turn to individual founders to try to explain the meaning of the original meaning of the First Amendment. But the leading founders' disagreement means there's no one single church-state position that should claim the exclusive authority of America's founding history. The first lesson we ought to draw, then, is that no one founder's position should be assumed to reflect the original meaning of the First Amendment's religion clauses. We should view appeals to any one founder with a large dose of circumspection, especially if an appeal claims to represent the views of the founders. It's very easy to pick and choose from among the founders to support different church-state jurisprudential results. I mean, I think I could have a side business in providing quotes to lawyers, looking to bolster their legal briefs. And too often, a single quotation from one founder is used to imply that the entire founding generation stood for a particular understanding of religious liberty. I mean, look, they all believed in religious liberty, at least Jefferson in theory did, but the leading founders disagreed on how that liberty was to be protected. So simply having a founder on your side is an inadequate legal argument. I mean, I could go through endless examples from Supreme Court jurisprudence to show how this is used and abused. Okay, many people at this point assume I'm next going to say that the founders are irrelevant, right? We disagree today, they disagreed back then. Well, let's just live in our own disagreements. Why figure out their disagreements? I disagree with that position. I mean, sort of obviously, right? I mean, that would be very bad for my career if it would be very bad for my book's sales if I said we should simply disregard the founders. The founders' disagreement actually makes them worth our study. I say this because they disagreed, they articulated their principles to engage one another. And hopefully I've shown you that they articulated principles in a far deeper and more thoughtful manner than we tend to today. So the second conclusion I'd have us draw is that understanding the founders' differences and the reasons, more importantly, the reasons why they disagreed can help us think through the proper relationship between church and state today. Disregarding the founders because they disagreed or because they wrote in a different age unnecessarily overlooks the thoughtfulness of some of America's most thoughtful political thinkers. So even if we can't turn to the founders in a deferential manner, we can certainly start in thinking through these issues on our own with their thought. Okay, so if we did turn to the founders, since we have turned to the founders, which founders' approach offers the most promise? Now, let me say, my main objective this afternoon is not to convince you of any one founder's position, but to illustrate the different positions, hopefully to help you further your own thinking about these matters. But at the end of the day, if history is meant to be useful, not just the study, we have to make evaluations. So which founder offers the best position? Something that can be said for all three of these founders, but for my money, I think Madison offers the most promise. So this is the third lesson I would have us draw. So let me leave the realm of a historian and scholar and reveal what I would take, or the lessons I would draw. The problem with Jefferson is pretty simple to my mind. Jefferson's position counsels discrimination against certain types of religion. Jefferson does not aim to be neutral towards religion. He aims to subjugate certain religious beliefs and practices. He aimed to subvert clerical influence in American society. So if one does not believe that is a noble goal, one does not think Jefferson's approach to church and state is worth following. Happy to say more about that later if you like. Many conservatives find Washington's approach to be the most attractive because it allows the state to support religion to promote civic purposes. If you share Washington's estimation of the beneficial qualities of religion, you're likely to sympathize with this approach. And there's much to be said in favor of it, I think, but let me suggest a few drawbacks. Washingtonianism, if I can use that term, views religion in a politically utilitarian manner. Take prayer in public school. A Washingtonian approach might defend prayer in public school the same way that Washington defended military chaplains. Prayer in public school might be said to improve discipline, to check misbehavior, to help secure respect for teachers. Yet understanding prayer in this way fundamentally misunderstands why we pray, at least from a religious point of view. It reduces a religious activity to a political end or political means. At minimum, this should make religious citizens nervous. Moreover, if communal prayers are said in public schools, who will author them? And I don't say this to criticize public school officials, but I'm not sure that it's wise to entrust writing prayers to them. That seems problematic to me. In general, the Washingtonian approach, I think, gives too much authority to the state over religion. So in those instances where the interests of the state diverge from the interests of religion, I think that could be very dangerous to religion and possibly even to religious liberty. Look, as a general rule, one should never disagree with George Washington about anything, but his principles of church and state, I think, would do more harm than good today. So by default, I'm left with Madison. But it's not just by default, because I think there's much that can be said for his position. By requiring the state to remain blind to religion, it avoids the hostility towards religion that Jeffersonianism counsels. It also avoids the utilitarianism that Washington's position leads to. But perhaps the reason I like Madison's approach the best is it embraces the old-fashioned idea of equality before the law. A religion-blind government could neither privilege nor penalize religious citizens as such. Religious citizens would have to be treated exactly the same as non-religious citizens. That strikes me, the idea of equality before the law strikes me as very attractive. A further strength is its transparency and its workability as a constitutional principles. In most cases, the idea of non-cognizance can be applied straightforwardly, consistently, and with a minimum amount of discretionary judgment. This is why lawyers hate Madison, at least this principle of Madison. It leaves them without much to do. All you have to ask is, does the state action in question take cognizance of religion? Now, that's not obvious in every case. I mean, we still need some lawyers, just not as many. Take participation by religious groups in publicly funded programs and state-funded programs. Non-cognizance would prevent the state from either including or excluding religious groups on account of their religious character. Religious groups could participate on equal terms as non-religious groups. So if you qualify for a grant, you can get it. If you don't, you don't. You don't need to take account of religion. Any state-funded program that limited participation to religious groups would be unconstitutional, but so would any program that excluded religious groups. The simplicity of the principle is one of its greatest assets because it helps us govern ourselves. Okay, let me finally draw to a close. I've tried to explain the church-state principles of our leading founding fathers. I've suggested that liberals and conservatives continue to appeal to the founders in part because both sides can find something of support for their positions in our history. But I hope I've made clear how both sides embrace only a partial understanding of our history. By clarifying what Jefferson and Madison and Washington actually thought and sought to do, how they sought to separate church and state, I hope this will help you and us together think more deeply, more profoundly, and better about how to protect religious liberty in the future. For reasons I too briefly sketched, I tried to explain why I favor Madison's position. I'm sorry I went on for so long, but thank you very much for your attention.